So we were discussing this Cobra doctrine. By the way, actually the one liable for compensation, for payment of compensation, is the state insurance fund. And this statement insurance fund shall be liable for injuries or death arising from. By the way, there are instances under the law where the state insurance fund is not liable for such compensation, like in the case of intoxication, self-inflicted injury, and in the case of what we call notorious negligence. So we have this intoxication, self-inflicted injury, or notorious negligence. So what are the instances under the law where the state insurance fund is not liable? We have number one, intoxication. What is intoxication? Well, as defined by the Supreme Court, intoxication takes place when a worker is entirely out of himself and there is injury or death. It's not mere drunkenness, but he is already in a state of intoxication where he is entirely out of himself. Another, in the case of self-inflicted injury. And the best example of self-inflicted injury is suicide. So suicide is not compensable under the law. Well, of course, we agree on the rule on self-preservation, the instinct of self-preservation, that the worker will not injure himself, will not kill himself. But there are instances where workers kill themselves. So the best example is suicide. It's not compensable. But there are instances under the law where this suicide is compensable. In the case of insanity, number two. In the case of uncontrollable impulse, or when the worker is in a state of delirium, yung nagdi-deliryo na. Diba alam niyo yung nagdi-deliryo? He is already in state of delirium. And there is injury or death, such is compensable. But as a general rule, suicide is not compensable. Another is notorious negligence, where there is no compensation. What is that? As defined by the Supreme Court, what is notorious negligence? The Supreme Court said that in notorious negligence, the worker or the employee willfully disregarded his own personal safety. In other words, if the worker disregarded willfully his own personal safety and there is injury or death, such injury or death is non-compensable. Assuming, let's take for an example a driver of National Bookstore. He delivered some books up there in Baguio at Seed Bookstore. So what happened? While negotiating the Cannon Road from Baguio down, he was negotiating at a speed of 100 miles per hour. Imagine, 100 miles per hour. A driver negotiating a winding zigzag road from from Baguio going to Manila. Naturally, the vehicle will, so we say, will fall in a ravine or in a precipice. Of course, upon impact of this vehicle down there, the vehicle burst into flames. No trace of the driver, no trace of the vehicle. There is death. Is death compensable? The Supreme Court said the death is compensable, not compensable. Why? Because the driver is notoriously negligent. Another, this is an actual case where a train worker embarked or alighted at the back platform of the train while moving backwards. Oh my God. So he was sandwiched between two coaches. Bobo. Ogag pa. So what happened? He died. Is the death compensable? Of course, that's not compensable. According to the Supreme Court, he is notoriously negligent. But I'll tell you one case where the Supreme Court said it is compensable and the employee or worker is not notoriously negligent. This is the Tanduay Ram doctrine or the Tanduay Ram case. What is this case about? In a cold winter night, a cold night, shall I say, what happened? There was a group of workers having a drinking spree. So what were they consuming? They were consuming tanduay. So after consuming several bottles of tanduay rum, one of the workers was still not intoxicated. So he told the others, "Oh, I still want to drink tanduay, but there is no more tanduay." So this worker saw a night oil of winter dip. "Oh, what is that? Perhaps that is tanduay rum." No, said one of the workers. "It's night oil of winter dip." "Oh, give me that night oil of winter dip." So what happened? Nilaklak yung night oil of winter dip. After some time, he died. Is the death compensable? The Supreme Court said it's compensable. Oh my God. Well, with due respect, I do not subscribe to this case now. But be that as it may, the Supreme Court said that it's compensable for the reason that his co-workers did not advise him that consuming the same would be deadly or fatal. So on that ground alone, according to the Supreme Court, this worker who consumed this night oil winter drink, his death is compensable. Oh, well, so take note of this. This might be given, although it's an old case, this might be given in the bar. So take note of this Tanduay Ram case. So I discussed this in view of this provision or right of the worker in Article 13, the right to just and humane conditions of work, and take note of this personal comfort doctrine. Every now and then, binibigay yan sa bar, or otherwise known as the principle of ministration. Another, we have this right to living wage. What is this right to living wage? This simply means that the workers should be provided or granted by law or through law enacted by Congress what we call a living wage. And of course, a living wage is not a mere subsistence wage, but it's a wage that can provide the worker's family to live in reasonable comfort. What do you mean by that? It simply means that the worker and the family enjoy what we call a decent standard of living. Take note of this. A decent standard of living. Meaning, they enjoy the basic necessities of life. Now, another is this, the right to peaceful concerted activities. Of course, any concerted activity that is conducted by the union should be peaceful. What is protected by law is peaceful concerted activity. Take note of this. Another, the right to strike in accordance with law. We are now going to discuss this law on strike. I told you before that if we are going to discuss some areas of the constitutional labor, I will connect right away to the pertinent labor code articles or provisions. So, since we are on strike, then we will now discuss on this law on strike. This is a bar area. Listen very carefully. Now, well, take note that there is a need for a long strike. Otherwise, there will be what we call, this might, shall I say, lead to an abnormal situation in the country that may affect not only the economy of the nation, but also affects the political situation of the country. This is the nature of industrial dispute. Any industrial dispute may affect the economy and the political stability of any country. That's why, as much as possible, we have to regulate the strike activity, because this might propel the economy of the nation into a downtrend. That is the reason why we should have a law on strike. All right. So what is a strike? Well, a strike is a concerted, a strike is a temporary stoppage of work arising out of a labor or industrial dispute. In other words, people, when you talk of a strike, the nature of a strike is temporary. Take note. Temporary stoppage of work. There's no such thing as permanent strike. It is a temporary nature of the strike. Take note of that. Now, so what are usually given the bar? Well, sometimes the bar examiner gives out questions on the types or classifications or kinds of strikes. So you should have a panoramic background on what are the different types of strikes. Number one, we have the authorized strike. What is this authorized strike? An authorized strike is one where the strike is approved by the majority of the total union membership. And this is determined by what machinery? This is determined by strike voting. Take note of that. Now, so if the union members approve of the strike, that is an authorized strike. Another is unauthorized. So what is an authorized strike? It's not approved by the union members. What is the requirement? The majority of the total union membership. In other words, people, when it is not approved by the union members, this strike is illegal. And this unauthorized strike is otherwise known as the wildcat strike. Binigay na sa bariyan, wildcat strike. Take note of these people, very important. Now, another is this particular strike. Particular strike is one that is staged by the union in a certain or particular economic enterprise or company or business enterprise, as the case may be. So say, for instance, there was a strike that is staged by the faculty members of FEU. That is a particular strike. The faculty union against FEU management. Faculty union of UST against UST management. This is a form of a particular strike. And the other one is general strike. Well, take note that general strike is against the law, for the reason that in general strike, there exists no employer-employee relationship. This is a strike staged not against particular employers, but this is a kind of strike that is addressed against the government. And the best example of a general strike is what we call Huelga ng Bayan. What is this Huelga ng Bayan? Say for instance, transportation strike in the entire Metro Manila area, or transportation strike the entire Philippines. In other words, it covers a larger portion of a state or of the country. That is a form of that is a general strike. That's why, in the words of the Supreme Court, general strike is a political, sympathetic form of strike. It is political in nature because the grievances are addressed not against the employers, but these grievances are addressed against the government. So it's political in nature. Sympathetic. No employer-employee relationship. Kaya tinawag na sympathetic. It's also a form of sympathetic strike. Political, sympathetic strike. And the best example of that is, of course, what we call Huelga ng Bayan. This was given the power already. Now, another is what we call a slowdown strike. From the word itself, slowdown, you have to imagine a slowdown. Jutay-jutay. Dahan-dahan. Huwag bigla-bigla. Kasi pag binigla mo, napupo. Kaya dapat dahan-dahan. In other words, when you talk of slowdown, here, the workers or the employees try to, reduce production. So, in the case of workers reducing production, they do not perform their work 100%. Perhaps they perform their work 10%, 20%, 30% only. They do not give their utmost efforts in producing. So this is a form of a slowdown. This is against the law because if you are an employee or worker, you are paid by the employer. So you have to perform your best effort to produce. But here, you do not produce. See, it would be violative of the principle of no work, no pay. A fair day's wage for a fair day's labor. I gave this in the bar. This principle, I gave this in the bar in 2008. Now, so in the case of slowdown strike, it's a violation of law. It's illegal. It's unwarranted. That is the reason why this should not be allowed. This is slowdown. Of course, other species of slowdown are what we call the sit-down strike, or what we call the quickie strike. In a sit-down strike, still the purpose is to slow down or reduce production. So the workers in a sit-down strike remain in the plant. Perhaps they remain in their seats where they are assigned to perform their work, but they refuse to perform. Rather than performing, they engage in chit-chat. What do you mean by chit-chat? Yung tinatawag nating chismis. Yung mga chismis sa pelikula. Hindi mo ba alam na si President Aquino ay hiwalay na sila ni Grace Lee? Mga ganon. Instead of performing their work, they chit-chat. They do not perform. This is against the law. This is illegal. That's why sit-down strike is illegal. And another is this quickie strike. In quickie strike, the workers may be outside of the plant or outside of the company. They do not perform any work. Of course, what is this quickie strike? Are they on a sitting position or standing position? Your guess is as good as mine. By the way, I'm just joking. By the way, so these are forms of illegal strike. This is slowdown strike, huh? Now, by the way, another. We have this sympathetic strike, as I've told a while ago. Sympathetic is illegal because there exists no employer-employee relationship. Another. We have this economic strike. You know, in economic strike, the union expects some economic concessions from the employer. But there was a deadlock on economic concessions during the bargaining process. That's why, when you talk of economic strike, this is actually the result of a collective bargaining deadlock. You're talking economic strike, where during the bargaining deadlock, the union submits or not submits a notice of strike with the regional NCMB, National Conciliation Mediation Board. In the case of economic strike, 30 days. In the case of unfair labor practice strike, 7 days. 15 days, and I say. 15 days, not 7. Now, by the way, so we have this economic strike. Another is unfair labor practice, where in unfair labor practice, it's a strike states because of the violation of the right of workers to self-organization. We're going to deal on this unfair labor practice later on. Very, very important. I gave one in this area in 2008 bar. By the way, another is this union recognition strike. Well, this is the case of Paspil, you know, this Paspil liner or Pascual liner, where the union struck because they wanted to compel Pascual liner or Paspil liner to recognize the union. This is a form of union recognition strike, which is against the law. Union recognition strike. Another, we have this lightning strike. Pwedeng ibigay sa baryan. Hindi pa binibigay sa baryan, lightning strike. Ano malay nyo? In future bar examinations or this year, this lightning strike will be given. What is lightning strike? This is a brief stoppage of work. And usually this is brought about by impromptu, sudden notice of union meetings. So here, there is an impromptu, sudden notice to all members of the union that there will be a union meeting. And it so happened in this company, of course, if majority of the employees are union members and there was an impromptu union meeting, many of the workers will not perform their work. And this is a form of what we call a lightning strike. Undeclared, impromptu, notice of union meeting. So take note of this, very important. Another. Well, actually, although we have discussed several types of strikes, under the law, there are only two types of strikes: legal strike and illegal strike. Legal, meaning to say that the requirements of the law on staging a strike were complied with. Illegal, certain requirements are not complied with. In other words, there are only two types of strike: legal and illegal strike. So take note of these people, very important. Now, we will now go to an area of the bar. And take note, you must memorize this by heart. The requirements for staging a lawful strike. Of course, we have number one, that the strike must be on a valid ground. The law provides for only two grounds. We have number one, bargaining deadlock and unfair labor practice. But there are authors who say that there are three grounds. One, bargaining deadlock or economic, unfair labor practice, and the other one is union busting. But take note that union busting is only a species of unfair labor practice, so why make it as three? But of course, we cannot, so we say, fault some authors, because actually this is also one of the, so we say, grounds. But but actually, under the law, there are only two. We have the collective bargaining deadlock and fair labor practice. Okay, now, number two requirement: it must be approved by the majority of total union membership. We have discussed this a while ago, that it should be an authorized strike. Otherwise, it will be declared as a wildcat strike, which is against the law. Another, a notice of strike that shall be filed with the regional NCMB, or the National Conciliation and Mediation Board. You know, there are some bar candidates who say that it shall be filed with the NLC. Oh my God. You know, I was lecturing in the provinces, and I asked one bar candidate, where will you file the notice of strike? Sir, in LRC. Oh my God. Kawawa. So by the way, the proper bodies, of course, the National Conciliation and Mediation Board. So, when the notice of strike is filed, with the regional NCMB, it is only on the basis of two grounds: bargaining deadlock, ULP. So assuming that there was a union that filed a notice of strike on wage distortion problem, this was given the bar already several times, wage distortion problem. So, a notice of strike filed based on wage distortion problem. It's already settled by law that a wage distortion problem is not a ground for filing a notice of strike. So, what should the NCMB do upon receipt of the notice of strike? Take note that the NCMB will declare whether the notice of strike is valid or not. So upon perusal of the grounds or the ground on the notice of strike, it was found out by the NCMB that it was grounded on wage distortion problem. Oh my God. So what should the NCMB do? The NCMB should drop. Remember, the NCMB should drop. VROP should drop the notice of strike from the dockets of notices of strike and issue what we call a PMO. What is a PMO? A PMO is a preventive mediation order. Take note, it was already declared by the Supreme Court that when the NCMB issues a PMO or a preventive mediation order, the union cannot stage a strike, otherwise the strike will be declared illegal. So, the NCMB issued a PMO, a preventive mediation order. And what is the legal effect of the PMO? The preventive mediation order converts, take note, converts the notice of strike into a preventive mediation case. Preventive mediation case. So, the notice of strike will now be under a preventive mediation proceeding. And who has jurisdiction over that? NCMB. Take note, it is still the NCMB. In other words, even if the notice of strike is not grounded on any strikeable issue, the NCMB shall continue with its efforts to narrow the gripe or the conflict or the dispute between the parties under its conciliation and mediation power with the issuance of what we call the preventive mediation order. Take note of this, very, very important. So take note, huh? Okay, now, in the case of a notice of strike, okay, assuming that it is grounded on a strikeable issue, economic strike, ULP, economic 30 days, ULP 15 days. Now, the period when you file a notice of strike is 30-day economic, 15 days economic, 30 days economic, 15 days ULP. This is known in law as the cooling off period. Tandaan yan, cooling off. Cool off. What is the purpose of the cooling off? The purpose of the cool off. So, syempre, alam niyo yan. You know this. Between intimate lovers, you know this cool off. You have to cool off to reduce the tension. So here, in order to reduce the tension that is exacerbating the situation between the employer and the union, they have to cool off. They have to reduce the tension between them. Yung mag-boyfriend, cool off muna tayo. Otherwise, that will lead to an eventual breakup. So here, the employer and the union should cool off. Yung tinatawag na cooling off period. 30 days economic, 15 days ULP. What is the purpose of this? For them to, shall we say, be given an avenue of settlement. And he will initiate this, because the NCMP, conciliation mediation. Another, can it be settled through the conclusive arbitration clause? Yes. That's why the Supreme Court provides that the CBA should contain what we call a conclusive arbitration clause, the grievance machinery and the voluntary arbitration procedures. Yeah, these are modes of, shall we say, settlement during the cooling period. Another, we have this, ito binigay na sa bar several times. This is known as the principle of improved offer balloting and the principle of reduced offer balloting, which are only available during the cooling out period. So take note of this. Very, very important. Now, in the case of ULP, 15 days, economic, 30 days. All right. Does it happen that the 7-day strike ban or the strike vote report be submitted also during the cooling off period? Yes. It does happen. It may happen that the strike vote report can be submitted during the cooling off period. Now, how will you now, shall we say, determine the 7-day strike ban? During the submission of the strike vote report during the cooling off period, or upon the expiration of the cooling off period? Take note. This is already settled this is already settled in capital medical case, where the Supreme Court said that it should be upon the expiration of the cooling off period. So 30 days plus 7 on the 37th. It's simple. It's a matter of mathematical formula. 30 plus 7, 37. All right. So now, people. Now, before I forget, you have to consider the fact that during the cooling off period, it may happen that there are, shall we say, acts committed by the employer against the union, like the dismissal of some officers of the union, which may constitute an unfair labor practice. Why? Because it is in the form of union busting. Now, question. Can the union immediately stage a strike? Well, this is already settled by the Supreme Court. Although there are some views by some erudite experts on labor law that since the life of the union in union busting is in danger or is at stake, there should be an immediate, shall we say, strike to be staged by the union. But the Supreme Court said that if there was union busting during the cooling off period, still they have to comply with the 30-day prior notice rule. and the 7-day strike ban. In other words, if these two requirements are not complied with, they cannot. Because according to Supreme Court, applying the labor code provides in every case. In other words, you cannot dispense with this requirement. So it should be complied with. This is the capital medical doctrine. You know these people. Now, so you have to comply with it. The 24-hour prior notice rule. What is this 24-hour prior notice rule? Yan ang alam nyo, you know people that I read, I also read the books of some of my colleagues, but sometimes they do not discuss this. They discuss separately with other matters. But you know, before you can submit a strike vote report, you have to comply with first the 24-hour prior notice rule. What is this 24-hour prior notice rule? Under the labor code, it provides that a notice shall be given or shall be submitted to the NCMB and the employer. In other words, the union should notify the NCMB within 24 hours. The union should notify the employer within 24 hours. As to the place, take note, place, date, time of strike voting. Place, date, time of strike voting. In other words, if this is not complied with, the strike is illegal, said the Supreme Court. Compliance with the 24-hour prior notice rule. Upon compliance of the 24-hour prior notice rule, then you can conduct your strike voting, after which you submit it to the NCMB. This is known as 7-day strike ban or the 7-day waiting period. You cannot forget this waiting period, 7-day waiting period. You know, there are some people who are fond of wait. Before they do the act, they have to wait. In labor law, there is also waiting period, 7 days waiting period, a 7-day waiting period, or the 7-day strike one. This is one of the requirements people. Another, of course, another requirement is that there must be compliance with the doctrine of means and purposes. What is this doctrine of means and purposes? If the purpose is legal, the means used in attaining the purpose must also be legal. Legal purpose plus legal means equals legal strike. Legal purpose, illegal means used, illegal strike. It's simple. You know, if you know this formula in labor law, you cannot go wrong. In other words, people, you have to, shall we say, memorize this by heart. Ito mga formula na to. If you know this formula, you can apply this formula in your essay type exam or in the MCQ type of exam. Take note of this. The doctrine of means and purposes. All right, I'll give you a concrete example. The law requires, the law provides for certain prohibitions during the strike. Like what? The union should not blockade the entire, should not blockade the only ingress and the only egress in the company premises. The union should not do acts that are illegal in nature. Imagine the union during the picketing stage throw Molotov bombs inside the company premises that gutted the whole building of the company. Well, this is illegal. The first the purpose is legal, but the means used in attaining the purpose are illegal. In the case of Sukhothai, you still remember this Sukhothai cuisine case where the union shouted invectives against the employer. Ang presidente ng union ay ganito, etc. Sabi ng Supreme Court, this libelous, slanderous, scurrilous remarks are uncalled for. They are illegal. So even if the purpose is legal, the means used in attaining the purpose are illegal. It will be declared illegal. Another, during the beginning stage, the waiters of Sukhothai restaurant advised the customers of Sukhothai not to enter the premises because the food being served are already poisoned by them. They put poisons. Oh my God. According to Supreme Court, that's illegal. Worse, when the guests were eating inside the Sukhothai cuisine restaurant, one of the union strikers shouted, "Granada!" So the guests come from different directions. The Supreme Court said it's illegal. So you have to comply with the doctrine of means and purposes. Take note of these people. Purpose must be legal, and the means used in attaining the purpose must also be legal. If the means used are illegal, the strike will be declared illegal. Okay, another. In the case of a strike in medical institutions, clinics or hospitals, the law mandates and requires an effective skeletal workforce to be instituted or formed by the union or by the employer in case of lockout. What is the purpose here? The purpose here is to have sufficient personnel to take care of the patients in the hospital. So take note of this, very important. These are the requirements for staging a lawful strike people. So take note of this, very important. Okay, another. So, if the strike is declared illegal, according to the Supreme Court, since the strikers, since the union officers masterminded, sila ang mastermind, they have masterminded the legal strike, then the union officers are liable for dismissal. Of course, you have to consider here the commission of illegal acts. Because in the case of rank and file strikers or rank and file employees who just joined this strike but did not commit illegal acts in the process, they have not committed illegal acts, or they did not actively participate in the commission of illegal acts, they are not liable for dismissal. Of course, as a rule, the union officers are liable for dismissal. Under what doctrine? Under the doctrine of vicarious liability. Take note of this. All right. Now, assuming that the strike is legal, take note of this scenario where the strike is legal. So the strike was declared legal. But just the same, although the strike is legal, there is damage to the company. So the employer required the union to pay for some damages because although the strike was declared legal, in some way or another, the employer sustained damages and injuries as a result of the legal strike. So what would be your answer here? Are the strikers liable to pay damages to the employer as a result of legal strike? The Supreme Court said no. Although the employer sustained injuries and damages during the strike, during the legal strike, they are not liable. Under what doctrine? Under the doctrine of damnum absque injuria, damage without injury. Take note, damage without injury. Pwedeng ibigay sa bar yan if the bar examiner is very imaginative. You know, sometimes when I dream, when I imagine of some questions that are sometimes given in the bar. Like this Cobra doctrine, which was my usual example in the bar review. This Kulangot doctrine and other doctrines I explained during the bar review programs. Imagine, these were given at the bar last year. Oh my God. Even my example on a house helper was required by the head of the family to provide some acts, provide some services. Imagine if ibinigay ni Justice Natura, it was given by Justice. Imagine this house helper providing private massage. Imagine this was given by Justice Natura. So I suppose Justice Natura and saka ako ay parang the same frequency of we have the same frequency as to the giving out of jokes. All right. So take note of these people. Now, are strikers entitled to back wages or back pay? As a general rule, no. No work, no pay principle applies. Fair day's wage for a fair day's labor applies. So take note of this. They are not entitled to back pay or back wages, as the case may be. Under the following instances, by way of exception, the striking workers are entitled to back pay or back wages. Number one, the striking workers were discriminatorily dismissed. Number one. Number two, the employer illegally locked out the striking workers. Number three, this was given in the bar already. And what was that? The striking workers unconditionally offered to return to work, but the offer was rejected by the employer. From that date on, the workers, the striking workers, are entitled to back pay or back wages. Take note of this, very, very important. Another area of the bar. Of course, we have lockout, same requirements. Lockout initiated by the employer, strike initiated by the employees. Same requirements as to lockout initiated by the employer. So there is such thing as legal lockout, illegal lockout as the case may be. By the way, during the picketing stage of a strike, although picketing is a part and parcel of a strike, may picketing be staged in the absence of a strike? May a strike be staged without picketing? You know, this is a bar area. Necessarily, in a strike, there must be picketing. But there can be picketing without strike. In other words, there can be picketing even in the absence of employer-employee relationship. This was already given in the bar. Why? Picketing, or otherwise known stranger picketing. Picketing is a part or form of freedom of speech and of the press, or freedom of expression, that is constitutionally guaranteed. So, even in the absence of employer-employee relationship, picketing can be staged. So, if this given the bar, you should know your legal anchor, and your legal anchor is the constitutional principle on freedom of expression, and picketing is a form of freedom of expression. Take note of this. Very, very important. So take note. Okay, now, we'll go further. So the right to strike in accordance with law. By the way, a strike of government employees. Take note, the strike of government employees is against the law. As a rule, government employees cannot stage a strike. On what grounds, on what principles, government employees cannot stage a strike? Number one, under the principle of states, under the principle of state sovereignty. Take note of the situation where government employees stage a strike, like bomberos, you know bomberos? Firemen, bomberos. Like policemen, military people. They cannot stage a strike. Why? They perform acts or responsibilities that are akin with the sovereignty. Acts of state sovereignty. So on the principle of state sovereignty, that's why applying American jurisprudence, in one American jurisprudence, the Supreme Court of the United States of America said that a strike of government employees is a form of an insurrection against public authority in the light of the principle of state sovereignty. So under the principle of state sovereignty, government employees cannot stage a strike. Take note of that. It is a form of an insurrection against public authority in the light of the principle of state sovereignty. This is my favorite area in the bar. Another, why government employees cannot stage a strike. Well, a strike of government employees is a civil service offense. Take note that government employees are civil servants. Government employees serve the people. They are civil servants. So if they are civil servants, they are governed by civil service. So a strike of these government employees is a civil service offense. And number three is often quoted or declared by the Supreme Court in several cases. According to the Supreme Court, a strike of government employees will tremendously affect the delivery of vital and basic services to the people. Imagine if there is a strike of AFP personnel, mga military people. Imagine if there is a strike of policemen. Imagine if there is a strike of jail guards. Imagine if there is a strike of firemen. Oh my God. This will, according to the Supreme Court, tremendously affect the delivery of vital and basic services to the people. So take note of this legal anchor. These are the legal anchor that will make you a lawyer. So take note of that. Huwag niyo akong sisisihin. Kung hindi niyo nakuha yan sa bar, mamaya binigay sa bar yan, hindi niyo alam, bumagsak kayo, sisisihin niyo ako. So, do it in such a way that you have to embed it in your heart. Ilagay niyo rito sa puso ninyo. Ito mga principles na to, because this will later on be your shall we say, your weapon in attacking the bar examiner. Of course, the bar examiner has his own sword. You counterattack the bar examiner with your wealth of knowledge that are stored in the granary of your mind. Take note of that. And when the time comes that you are now answering your bar questions, this granary of knowledge will flow out smoothly through your veins and through the veins of your fingers until finally through your pen or your sign pen. Of course, when you become a lawyer, you invite me, of course. Huh? Okay. By the way, let's go further. Another right of the worker under Article 13 of the Constitution. I gave this in the in 2008. The right to participate in policy and decision-making processes with the management, known as the principle of shared responsibility, co-determination, co-sharing, or the principle of participatory democracy in labor relations. But if you know principle of shared responsibility, co-determination, co-sharing, pwede na yun. But of course, you should know other terms that are of the same essence or the same concept as the case may be. So take note of this. Now, of course, the best example of this principle of shared responsibility, how would you concretize this principle of shared responsibility, people? Well, the best example is through labor management committees, or through what we call the collective bargaining process. You know, in collective bargaining process, the union and the employer share. They co-share. They co-determine certain policies, especially policies that affect the rights of the workers, because policies that are management per se, of course, beyond the shall we say, the principle of shared responsibility, because the principle of shared responsibility, as far as the workers are concerned, confined only to matters that affect the rights of the workers. And this was exemplified by the Supreme Court in one case, Paul versus NLRC, Well, the Supreme Court had the occasion to explain two types of management prerogatives. Management prerogatives in the operation of the business per se, and management prerogatives that affect the rights of the workers. Management prerogatives that are in relation, or that are that affect the rights, that affect only the operation of the management per se. The employees cannot co-share. The employees cannot determine with the management. Only those that are, only those that affect the rights of the workers. So, such as what? Give me an example. The best example is the drafting, approval of the Code of Conduct and Discipline. This Code of Conduct and Discipline, people, affects the rights of the workers. So the Supreme Court said the union or the workers should be consulted. Otherwise, it would violate this constitutional mandate on co-sharing, co-determination, or otherwise known as the principle of shared responsibility. Well, there are other provisions of the Constitution on co-sharing, or in the words of the Supreme Court, they co-share in some policies. Another important area here is this principle of tripartism, which in one way or the other is also within the concept of co-sharing. The principle of tripartism, you pardon today's try to relate this principle of tripartism, where the employer, the union, and the government converge in a convocation or a conference aimed at drafting major labor policies, aimed at resolving major labor disputes. That is the very essence of this principle of tripartism. But of course, it has no coercive effect. It has no, these are not, shall we say, it has no coercive, shall we say, effect upon the employer, the union, and the government. But this might, or this will guide policymakers like the government in drafting, shall we say, policies on this matter, which has been the subject of this tripartite conference under the principle of tripartite, principle of tripartism. So, by the way, let's have another area after this pause.